Picture two people with the same broken leg. One slipped on a wet kitchen floor, the other was hit by a careless driver. In many countries, their paths can divide immediately. One person may look for an insurer, the other may look for a lawyer and try to prove fault in court. New Zealand built a different front door. It is called ACC. The scheme usually asks whether an accident caused a covered injury, not who deserves the blame. That makes the people who give clinical advice inside ACC more important than their quiet job title suggests. Their advice can help decide whether that front door opens, what support follows, and when it closes. In July 2026, more than 50 senior doctors working as ACC medical advisors planned industrial action. Their union said morale was at an all-time low. It wanted a collective agreement that included personal grievance protections and a safer way for doctors to speak up about possible harm. ACC said it supported the right of staff to take industrial action and would continue to act as a good employer. The dispute is about employment conditions. Behind it sits a much larger New Zealand question: who guards the gate in a no-fault injury system? To understand that gate, go back to 1967. A royal commission led by Sir Owen Woodhouse proposed a broad public system for injury support. ACC began operating in 1974. The bargain was bold. People in New Zealand would receive cover for accidental injury without first proving that another person was at fault. Visitors would be covered too. Support could include treatment, help at home, rehabilitation, and up to 80% of a person's usual income when an injury stopped them working. In exchange, most people lost the ordinary right to sue for damages over a personal injury covered by the scheme. Section 317 of the Accident Compensation Act 2001 contains that legal bar. This is why ACC is more than an insurance company. It is one side of a social bargain. The bargain solves a painful problem with fault-based lawsuits. A court case can take years. The injured person may have to prove who caused the harm, how careless that person was, and how much money the injury cost. Some people win large amounts. Others with equally serious needs may receive little because nobody was legally at fault, or because they cannot afford the fight. No-fault cover makes the first question simpler. Was there a covered injury caused by an accident? Simple does not mean easy. Imagine knee pain after a fall. How much was caused by that exact fall, and how much came from a condition that had developed over years? Or imagine a problem after medical treatment. Was it an injury caused by treatment, an expected result, or the illness continuing on its own? Those are not only paperwork questions. They require medicine, evidence, and law to meet in the same file. Most ACC claims are straightforward. New Zealand records more than 2 million accepted claims in a typical recent year, and ordinary claims can move quickly. Complex cases need closer human assessment. ACC staff may ask for patient notes, claim history, information from health providers, and medical, legal, or technical advice. A medical advisor is not the treating doctor. The advisor may never meet the injured person. The role is to help ACC understand the medical evidence within the rules of the scheme. The final cover or entitlement decision belongs to ACC, but clinical guidance can carry real weight. That creates a difficult professional position. The doctor works for the organization that must make consistent decisions and manage a large public fund. The same doctor remains bound by a professional duty to use clinical judgment and put safety first. Usually those duties can sit together. Sometimes they can pull in different directions. This is where employment protections stop being an office detail. A personal grievance is a legal process an employee can use when they believe an employer has treated them unjustifiably. It can cover matters such as unjustified disadvantage or dismissal, although the law has different dismissal rules for some high-income employees. Speaking up protections deal with a related fear: what happens to a worker who raises a serious concern inside the organization. The union's claim does not prove that ACC has caused systemic clinical harm, nor does a planned strike prove that any particular claim decision was wrong. The important point is narrower. A system that depends on internal expert advice needs experts who believe they can disagree honestly. If a doctor sees a pattern that may harm injured people, the public interest is served when that concern can be tested rather than buried. If the concern is mistaken, a fair process can show why. If it is sound, the organization can correct the pattern before it reaches more files. Claimants also have an outside protection. A person who disagrees with an ACC decision can ask for an independent review. That matters because no internal decision should be beyond challenge. Yet review is not a complete answer. An injured person may already be living with pain, reduced income, and uncertainty. Every extra letter, medical report, and month of waiting has a human cost. Good decisions at the first gate still matter. There is also a deeper question of trust. When New Zealand removed most injury lawsuits, it moved enormous power away from the civil courtroom. That power did not disappear. It moved into legislation, claim files, clinical opinions, review hearings, and the daily culture inside ACC. The no-fault bargain did not promise that every claim would be accepted. It promised a better way to decide who receives support after injury. That promise depends on more than a law passed by Parliament. It depends on the quality of the people at the gate, the evidence they can use, the freedom they have to speak, and the ability of an injured person to challenge the answer. New Zealand did not remove conflict from personal injury. It moved the conflict from proving blame to proving cover. That is why a dispute involving 50 medical advisors belongs to the whole country. They work inside one of New Zealand's most unusual public promises. When the gatekeepers say they do not feel safe enough to speak, the promise itself deserves a careful look.